So welcome back. It is my pleasure to introduce our final lecturer of today, Professor Rose Cuison-Villazor. Professor Cuison-Villazor is Professor of Law and Chancellor's Social Justice Scholar at Rutgers Law School, where she previously served as Interim Co-Dean from 2021 to 2023 and Vice Dean from 2019 to 2021. Professor Cuison-Villazor is also director of the Center for Immigration Law, Policy, and Social Justice, which conducts publicly engaged research and policy work on behalf of non-citizens and their families. During the 2023-2024 academic year, she will serve as a fellow in residence at the Birnbaum Women's Leadership Center at NYU School of Law. While at the BWLC, she will work on a book project that explores the extent to which mid-20th century immigration, military, and citizenship laws deployed race and gender to separate mixed-race families from living together in the United States. Professor Cuison-Villazor's overall research agenda examines laws, policies, and norms that determine membership and belonging. She teaches and writes in the areas of immigration and citizenship law, property law, critical race theory, Asian Americans in the law, U.S. territorial law, and equal protection law. Professor Cuison-Villazor's scholarship has appeared or will appear in top law journals in the country, including Columbia Law Review, Harvard Law Review Forum, Michigan Law Review, and New York University Law Review, and forthcoming publication in the Western New England Law Review. Her recent books include Race and Races, Cases and Resources for a Diverse America, 4th edition, and Integrating Spaces, Property, Race, and Identity, forthcoming in 2023. Professor Cuison-Villazor obtained her LLM from Columbia Law School and her JD from American University. Welcome, Professor Cuison-Villazor.
Thank you so much, Andrew, and thank you to the Western New England Law Review and Dean Zelda Harris for inviting me to participate in this incredibly powerful conference. I have learned so much from the speakers and panelists and the discussions from today, and it truly is an honor to be part of this symposium. Since I am one of the last speakers of the day, I thought that I would begin my talk by connecting my lecture with Richard Rothstein's Color of Law. As a property law and race scholar, I am a big fan of Rothstein's work, and I consider his book, Color of Law, one of the most influential books of our time. In fact, I usually purchase extra copies of Color of Law and distribute them to some of my students at the end of the semester. One of the points that I most appreciate about Color of Law is how Rothstein addresses the myth of de facto segregation, and he does this by sharing his research, demonstrating that ongoing wealth inequality today stemmed not from de facto segregation, but from de jure segregation perpetrated by federal, state, and local governments. Essentially, in his book, Color of Law, and forthcoming book that he just talked about, Just Action, Rothstein seeks to reorient our collective memory. In the field of social legal inquiry of law and memory, focusing on collective memory is a valuable exercise because our memories of laws, what we remember or not remember about them, influence the creation, enforcement, and interpretation of new laws. In other words, Rothstein asks us not to forget about what happened in the past because they are part of our racial shared history and they have ongoing contemporary effects. My lecture today similarly encourages us to remember the past and to consider the effect that they have today. The title of my talk is 2023 Alien Land Laws and Historical Amnesia, and it will explore the intersection of immigration, citizenship, and race that I'm seeing right now in several laws that have been passed in various states. By new alien land law, I am referring to laws such as the one passed in Florida in May 2023 that prohibit Chinese from owning land. But Florida is not alone. Alabama, Indiana, and Montana have passed similar laws, and there are multiple bills under consideration that have been proposed in other states. A lawsuit has been filed against the Florida law, and in full disclosure, I am part of a team writing an amicus brief, which includes Professor Jack Chin of UC Davis, who you heard from this morning, Professor Bob Chang of Seattle University, and lawyers from Boston who are from the law firm of Foley Hoag. And as a team, we are supporting the challenge to Florida's Alien Land Law, or SB 264. I argue today that these laws are reminiscent of alien land laws in the 1920s that denied persons who were, quote, ineligible to citizenship, end quote, from owning land. The phrase ineligible for citizenship or ineligible to citizenship was euphemism for the denial of Asian immigrants from being able to naturalize and become U.S. citizens. By not being eligible to become U.S. citizens, persons who were deemed ineligible to citizenship were also racially barred from immigrating to the United States. For those Asian immigrants who were already in the United States, their racial ineligibility for citizenship prohibited their ability to own land in several states. The alien land laws that have been passed this year, including in Florida, underscore part of our history that seems to have been forgotten, but they continue to have contemporary relevance. These laws shape the racial makeup of our country and may be attributed or may have caused the perpetual foreigner stereotype of Asian Americans. With the balance of my time, I'll divide my remarks in three parts. First, I'll briefly discuss how immigration, citizenship, and race intersected to influence the racial and citizenship makeup of the United States. Second, I will discuss the alien land laws of the 1920s and cases that challenged them. As I will emphasize in that part of my talk, the U.S. Supreme Court in 4 cases in 1923 actually upheld those alien land laws. But for many years, since 1923, states have repealed those laws, those alien land laws, and equal protection jurisprudence has developed such that these laws would be considered racially discriminatory today. And then finally, I'll return us to Florida's alien land law and share with you some of the arguments that are publicly available with respect to the challenge of this law. I argue that both passage of the law and the district court's opinion, which allowed the law to be enforced, demonstrate historical amnesia about the earlier alien land laws of the 1920s. The dangers of not remembering our past means that the same mistakes are being made again today. Let me first begin by talking about immigration, race, and citizenship and the intersections among them. Florida's alien land law provides a useful starting point to talking about the intersections among these three, because the history of immigration and citizenship law in this country demonstrate the ways in which Congress limited immigration because of race, and also for those immigrants who were able to be in the United States despite these racial inadmissibility, Congress ensured that they were not able to become U.S. citizens. Let's first talk about citizenship law. Congress saw fit to ensure that citizenship would be reserved for those persons deemed desirable immigrants. One of the first statutes passed by Congress is the 1790 Naturalization Act, which provided that only free white persons would be eligible for naturalization. Congress subsequently amended that statute in 1870 after the passage of the Civil Rights Amendments to provide that aliens of African nativity and persons of African descent would be eligible for citizenship. The Supreme Court later confirmed that only those persons who are white or of African descent were eligible for naturalization. In Ozawa versus United States, the Supreme Court upheld the denial of naturalization of a Japanese immigrant because he is not white. Relying on what the court said were, quote, numerous scientific authorities, the court concluded that Japanese are clearly of a race which is not Caucasian. But then just 3 months later in Thin versus United States, a high caste Hindu whom the court acknowledged was considered Aryan or Caucasian was nevertheless deemed not white for purposes of naturalization laws. The court explained that we must not fail to keep in mind that the statute, the Naturalization Act of 1870, does not employ the word Caucasian, but instead it contains the words white persons. And these words are, according to the court, of common speech and not of scientific origin. The court stated, it may be true that the blonde Scandinavian and the brown Hindu have a common ancestor in the dim reaches of antiquity, but the average man knows perfectly well that there are unmistakable and profound differences between them. So instead of relying on scientific sources to interpret the meaning of free white persons, as the court purported to do in Ozawa just 3 months earlier, the court in Thin interpreted the phrase using words of familiar speech and based on what the, quote, original framers of the law would have intended to include only those persons or men whom they knew was white. Specifically, the court explained, the immigration of that day was almost exclusively from the British Isles and northwestern Europe, whence they and their forebears had come. When they extended the privilege of American citizenship to any alien being a free white person, it was these immigrants, bone of their bone and flesh of their flesh, and their kind whom they must have had affirmatively in mind. This racial bar on citizenship would not be repealed until 1952, although Congress allowed some Asian groups to be eligible for naturalization in the 1940s. Professors Jack Chin and Paul Finkelman argued in a recent paper that the 1790 Naturalization Act and subsequent amendments were done by Congress in order to demonstrate Congress's intent to establish and encourage only white immigrants to come to the United States. But how did Congress discourage other non-white immigrants from coming to the United States? And let me then turn to immigration law. Many attending the symposium today are likely familiar with the 1882 Chinese Exclusion Act, but might not be as familiar with the 1875 Page Act, which barred the entry of immigrants entering the United States for lewd and immoral purposes. This law was directed at Chinese who were stereotyped as prostitutes, and it would serve as a precursor to the Chinese Exclusion Act of 1882, which explicitly barred the entry of Chinese laborers for 10 years. The Supreme Court in the 1889 case of Che Chang-ping versus United States upheld the constitutionality of the statute, stating that Congress had the power to exclude the presence of foreigners of a different race in this country who will not assimilate with us and who are deemed to be dangerous to its peace and security, according to the court. Che Chang-ping, I should note, is still on the books and to this day gets cited for the proposition that Congress has plenary authority over immigration law. Congress did not stop with the 1882 statute. In 1917, Congress extended the bar against Chinese to all immigrants coming from the Asiatic barred zone. Japanese were able to continue immigrating to the United States if their own government allowed them to leave. But in 1924, Congress passed a law that provided that persons who were not eligible for citizenship were not admissible to the United States. What that meant was that Japanese and all those who remained racially not allowed to naturalize from having the ability, it prevented them from having the ability to immigrate to the United States in the first instance. And this particular bar created in 1924 against the immigration of people who were not allowed to become U.S. citizens continued until well into 1952, when Congress finally overhauled the country's immigration laws and repealed the racial restriction on citizenship. But it's important to remember also that even in 1952, prescriptions against the entry of Asian immigrants continued through the imposition of racial quotas. Only 100 immigrants per Asian country were allowed to enter the United States every year, beginning in 1952. It was not until 1965 that Congress repealed the national origins quotas that mainly affected Asian immigrants. So in sum, I've explained part of the background here with respect to immigration law and citizenship laws that Congress used in order to limit the presence and political membership of Asian immigrants and other immigrants who were deemed undesirable. What role did immigration and citizenship law played in the alien land laws? Let me turn to that next. In the early 1900s, several states, including Arizona, California, Florida, Idaho, Kansas, Louisiana, Minnesota, Missouri, Montana, Oregon, New Mexico, Texas, Washington, and Wyoming, that's a lot of states I know, passed laws that prescribe persons who were ineligible to citizenship under federal citizenship laws from owning land. So let me repeat that. In those states, if a person is ineligible to citizenship, they are prohibited from owning land. I had written a law review article about California's alien land law, and so I will focus on that law during my talk. In 1913, white farmers who felt threatened by Japanese farmers convinced the state legislature to pass the state's law and to pass a law that prohibited persons who were not eligible from citizenship from owning land. State political leaders understood that this law would help deter Japanese immigrants from staying and working in California. As the Attorney General of California stated in his support of the 1913 Alien Land Law, he said, "It is unimportant and foreign to the question whether a particular race is inferior. The simple and single question is the race desirable?" The law seeks to limit their presence by curtailing their privileges, which they may enjoy here, for they will not come in large numbers and long abide with us if they may not acquire land. So the 1913 law passed, but Californians were not satisfied with that. And so in 1920, California voters passed an initiative that made the state's alien land law even more restrictive by prohibiting leaseholds of agricultural lands, preventing corporations from owning land, and prohibiting the placement of agricultural lands in guardianships or trusteeships. Again, the targeted group of this law in 1920 was Japanese. Constitutional challenges were brought not only against California's alien land law, but also Washington state's alien land law, among other grounds on equal protection under the Equal Protection Clause of the 14th Amendment. In 4 cases decided in 1923, the Supreme Court upheld the constitutionality of both California and Washington's alien land laws. In Terrace versus Thompson, the Supreme Court upheld Washington's alien land law, which prohibited persons who were similar to the California alien land law by prohibiting those who were not eligible to become citizens from owning land. But Washington's alien land law was slightly different. It prohibited those persons who have not declared in good faith to become U.S. citizens from owning land. A U.S. citizen farmer, Mr. Terrace, wanted to lease land to Mr. Nakatsuka, a Japanese farmer. And Mr. Terrace argued that Washington's alien land law deprived him, a U.S. citizen, of his due process and equal protection right to lease his land to the Japanese farmer, Mr. Nakatsuka. As I had mentioned earlier, Japanese were not eligible to naturalize, and so Mr. Nakatsuka could not have filed a good faith intention to become a U.S. citizen. The Supreme Court disagreed with Mr. Terrace's argument that he was deprived of equal protection under the law. The court did recognize that in Yigwo versus United States, the court had held that the 14th Amendment's Equal Protection Clause protects against arbitrary and capricious or unjust discriminatory action of the state. But the court held that there was no equal protection violation. First, the court said that the 14th Amendment did not take away from the state those powers, those police powers that were reserved at the time of the adoption of the Constitution. The state of Washington, like other states, according to the court, has wide discretion in determining its own public policy and what measures are necessary for its own protection and properly to promote the safety, peace, and good order of its people. And further, the court said that each state, in the absence of any treaty provision to the contrary, has the power to deny aliens the right to own land within its borders. Next, the court emphasized that the classification is based on eligibility and purpose to naturalize, and that the state may properly assume that the considerations upon which Congress had made such classifications are substantial and reasonable grounds for them to pass their own state law. Because the law applied to all persons of whatever color or race who have not declared their intention in good faith to become citizens, the law did not violate the Equal Protection Clause. So in other words, the Supreme Court in Terrace allowed the state to rely on congressional law that denied eligibility for citizenship as a basis for denying Japanese Americans and immigrants the ability to own or lease their land. 25 years later, a new challenge was brought to California's alien land law, and this time it was partially successful. In Oyama versus California, 2 Japanese Americans, a father who was not eligible for citizenship, and his son, a U.S. citizen, he was born in California, challenged the law on equal protection grounds. This time, the U.S. Supreme Court agreed, but addressed that the law was unconstitutional as applied to the son only. The majority opinion held that California discriminated against the U.S. citizen's son solely on his parents' country of origin, and that there was no compelling justification to support such discrimination. As an American citizen, the court held that the statute created a statutory presumption that the land had been purchased for him by his father and placed under his name and was not considered a bona fide gift at all. By contrast, other U.S. citizens whose parents were not Japanese nationals did not have their gifts questioned. As such, the Alien Land Law violated the U.S. citizen's son's rights under the Equal Protection Clause of the 14th Amendment, according to the court. And having decided the application of the 14th Amendment the application of the Alien Land Law to U.S. citizens, the court did not see fit to decide whether, as applied to the father, the father who was not eligible for citizenship, that the court decided not to address the constitutionality as applied to the non-citizen father. It should be noted that there were justices who wrote concurring opinions who would have struck down California's Alien Land Law. Justice Murphy, for example, pointed out that the law was intended to exclude Japanese from owning and using the land, and that the Equal Protection Clause applied to persons and not just citizens. But although Oyama did not fully strike down California's Alien Land Law, it did lead to the end of the state's enforcement of the law. And just a few months after the court decided Oyama, California voters rejected an initiative that would have amended the law, and then 4 years And 4 years later, California's Supreme Court struck down the law as unconstitutional in Fuji versus California. Soon, other states also repealed their alien land laws, or their state Supreme Courts also chose to reverse previous decisions that upheld their alien land laws constitutionality. So in sum, for decades, alien land laws, particularly in the 1900s, relied on racially discriminatory citizenship laws that have since been repealed. And these alien land laws have long been deemed unconstitutional. Having written my article on Oyama versus California and California's alien land law almost 13 years ago, I had thought that the alien land laws are a thing of the past. Turns out I was wrong. So now let me turn to my third and final part of my talk, a discussion of today's alien land laws. 75 years since Oyama and nearly 100 years since Terrace, Florida passed an alien land law. On May 28, 2023, Florida's Governor DeSantis signed SB 264 into law. SB 264 imposes new restrictions on persons and entities from foreign countries of concern, defined as China, Russia, Iran, North Korea, Cuba, Venezuela, and Syria. First, SB 264 prescribes, quote, foreign principles from owning or acquiring agricultural land or real property within 10 miles of any military installation or critical infrastructure facility in Florida. Foreign principles include individuals whose domicile is in a foreign country of concern and who are not U.S. citizens or lawful permanent residents. An exception is allowed for foreign principals who are natural persons who have valid non-tourist visas or have been granted asylum to purchase residential real property. Those persons who currently own land who are subject to the law, that is the definition of a foreign principal, would be required to register their property with Florida's Department of Economic Opportunity. A second thing that SB 264 did prohibits the purchase or acquisition of real property by the People's Republic of China. It also prohibits Chinese political and corporate entities and any person who is domiciled in the People's Republic of China and who is not a citizen or lawful permanent resident of the United States from purchasing or owning any real property in the state. An exception has also been provided for persons with valid non-tourist visas or have been granted asylum. Importantly, the failure to comply with the restrictions and registration requirements may result in civil penalties, including a fine of $1,000 for each day that registration is delayed, and forfeiture of any real property owned or acquired in violation of the statute. In signing the law, Governor DeSantis explained, Florida is taking action to stand against the United States' greatest geopolitical threat, the Chinese Communist Party. I'm proud to sign this legislation to stop the purchase of our farmland and land near our military bases and critical infrastructure by Chinese agents, to stop sensitive digital data from being stored in China, and to stop CCP influence in our education system from grade school to grad school. We are following through on our commitment to crack down on communist China. Given this discriminatory nature of the law, a lawsuit was brought to preliminary and joined its enforcement. 4 Chinese individuals residing in Florida and a real estate brokerage that regularly engages in business with Chinese clients filed a motion to preliminarily enjoin the statute. They argue that the statute is unconstitutional because, among other things, it violates equal protection and due process guarantees under the Constitution. They also argue that the law intrudes on the federal government's power to superintend foreign affairs, foreign investment, and national security, and that it recalls a wrongful animus of similar state laws from decades past. Laws that were eventually struck down by courts or repealed by legislatures. With respect to their equal protection argument, the plaintiffs relied on Oyama versus California and argued that as a result of the Oyama decision and other developments in equal protection case law, most of the country's alien land laws were repealed or struck down in the 1950s. As I explained earlier, I am part of a team that is supporting the challenge, and in our brief, we argue that the Florida law is unconstitutional. As we wrote, race-based alien land laws like Florida's are stain on American history. Since the mid-20th century, these laws, aimed at curtailing the rights of Asian persons, have historically been struck down as invidiously discriminatory. Our goal in our amicus is to provide historical background and show that the alien land laws have a history of promoting discrimination against Asian persons and have been deemed unconstitutional for well over 75 years. Florida essentially is repeating history by scapegoating and discriminating against Asian persons under the guise of national security. The United States also submitted an amicus brief supporting the plaintiffs, and the state was supported by other states that including Idaho, Arkansas, and Georgia, and other states that held that states have the power under the police, under the 10th Amendment police powers to continue to control the ability of non-citizens to own land. The state's main argument was Terrace versus Thompson, in which it said that, the state claimed that the plaintiffs and amici ignored. The state disagreed with the argument that developments in equal protection law have deemed the SB 264 unconstitutional, and that the district court was obligated to follow Supreme Court precedent that has direct application in the case. How did the district court rule? Well, on August 17, 2023, the district court denied the motion for preliminary injunction. The court held that the law does not discriminate against non-citizens based on the particular country in which one was born. Instead, the court said that the challenge law is facially neutral as to race and national origin. But the court did recognize that SB 264 is facially classified by alienage, but then noted that the question is whether the alienage classification warrants strict scrutiny. The court then held that because Terrace versus Thompson allowed under the 14th Amendment to authorize the states the power to deny to aliens the right to own land within their borders, then so too can the state of Florida do so in passing SB 264. The court said that the law challenge here is entitled to like deference. Like the statutes at issue in the Terrace cases, Florida enacted the challenge law pursuant to states' long recognized power to deny to aliens the right to own land within their borders. Let me now conclude, so as I am nearly out of time. We are once again facing discriminatory alien land laws. And when I wrote my article in 2010 in the Oyama case and California's alien land law, I had thought that we had already moved past that part of our racial history. Turns out, as I said earlier, that I was mistaken, and states like Florida today have decided to bring them back. Richard Rothstein encouraged us in Color of Law to recognize our historical past. We must do so today as well, in looking at these states like Florida in the past new alien land laws. Florida's alien land law, as we wrote in our brief, the amicus brief, is a law that is under the pretext of national security that will invite another era of anti-Asian immigrant sentiment and result in discrimination against all Asian persons. Thank you.
Thank you so much, Professor Cuison-Villazor, for that insightful lecture. And I will now introduce Western New England School of Law Professor Claudia Quintero, who will be giving the closing